Good morning, everyone. We were studying in the previous class about different types of rights which are guaranteed by our constitution. And in this regard, we have studied about right to equality, right to freedom, and right against exploitation and right to freedom of religion. We were doing this right to freedom of religion, and under this, what we have studied that our constitution gave us freedom of conscience and free profession, practice, and propagation of religion. It means कि everyone is free to profess any religion, to practice any religion, and to propagate any religion. And moreover, our constitution gives us freedom of conscience, which means everyone is free to not to follow any religion. If he feels like that, then he is free to not to follow any religion. And in this regard, what is need to be explained that the right of propagation of religion, which is given by our constitution, has become a contentious issue, because many time it happens that people propagate their religion, and not only they propagate, but they in the very unlawful manner, unconstitutional manner, they force the people to convert their religion. When we see our constitution, the constitution allows conversion. It is not any kind of there is no not any kind of restriction on the conversion. Anyone can convert from one religion to another religion, but this conversion should be completely peaceful, and it should be based on the desire of the person, and no one can force him or her to change his or her religion. But what we find in practice, there is a lot of problem arose regarding this, because many times different types of pressures are put on the people in order to change their religion. Then the another freedom under this right to freedom is freedom to manage religious affairs. All the people of different religion has a right to manage their religious affairs in whatever manner they want, in whatever practices are there in the religion. According to those practices, everyone is free to manage the religious affairs. Then freedom to pay taxes for promotion of any particular religion. In order to promote any religion, everyone is free to pay taxes for the promotion of religion, and the government cannot stop this kind of activity on the basis of secularism, that our constitution adopts secularism, and it means that there should not be any taxation for for the purpose of religion. This tax will not be taken by the government, but any organization can use this type of taking of taxes from the people for the promotion of particular religion. Then our constitution also guarantees freedom to attend religious instructions or worship in certain educational institute. And in some educational institute, our constitution gave us freedom to attend religious instruction or worship. In the next right is about cultural and educational right, and when we will discuss that right regarding many things will become more clear. Now, what is important about this right to freedom of religion is that our constitution is based on the concept of secularism, and secularism means all religion are equal in the eyes of the state, and our country does not have any official religion. Every religion is same, and the government treat every religion in the same manner. This is very much important because India is a country of diversity. The most unique feature of Indian society is its diversity. Unity in diversity is best the best example of unity in diversity is India. So, in order to promote this diversity, our constitution makers were not of the view that the diversity of language, the diversity of culture, or the diversity of religion will hinder, yeah, or obstruct the path of unity of the people of India. But instead, what they felt that this diversity should be encouraged, and the more we encourage, the more we recognize the diversity, the more people will become a part of the country, and their belongingness to the country will increase. In this way, our constitution makers adopted the concept of secularism, and that is the reason that under our constitution has given us right to freedom of religion. We also saw under the right to equality that our constitution also guarantees that the government will not discriminate on the basis of religion in giving employment, and the institution run by the state will not preach any religion or give religious education, nor will they favor persons of any religion. So these are the various aspects of secularism. Now, there is another right, that is cultural and educational right. In this regard, first you have to understand the concept of minority. Just now we were talking about the diversity that is existing in India, and because of this diversity, what happens that it is very much natural that in a society like India, there are many people who are small in number compared to some other group. And this group of people, which is small in number, is called minority. And uh, this minority can be on the basis of religion, or this minority can be basis of culture, or on the basis of language also. And what our constitution makers were very much aware of the fear and insecurity of the minorities in any society. It is very much natural for the minority to be in fear. There exists an atmosphere of insecurity among the people of minorities because they are less in number, and they are always afraid of the majority group. They are afraid that anytime the majority group can crush them, can crush their culture, can crush their language, can crush their way of thinking, and it can impose its own culture on the it can impose its own language, it can impose its own religion on the minority group. So what was needed, there was a need of safeguards, who were needed to be safeguarded minority group. So our constitution makers uh, um, provided some safeguards for the protection of the interest of minority. Our constitution makers provided some safeguards so that the atmosphere of fear and insecurity should be removed from the mind of minorities. And in this connection, this right, cultural and educational right, was guaranteed by the constitution. Minorities are groups that have common language or religion, and in a particular part of the country or in the country as a whole, they are outnumbered by some other social section. So this is minority, which are either in a part of the country or in the whole country. They are less in number. There are other groups which are much more in number if we compare the number of the two groups. And the minority, the people belonging to minority group have either they have common language or common religion. Such communities have a culture, language, and a script of their own, and have the right to conserve and develop these. So our constitution makers guaranteed this right to the minority group, that the minorities, the lingual and religious minority group, have the right to conserve and develop their culture, to conserve and develop their language. So, what happens in this regard? What is the right of the minority group? The right of the minority group is that they can set up their own educational institutions. All minorities, either it may be religious minority, it may be linguistic minority, all minorities can set up their own educational institutions. And by setting up the educational institutes, what are they doing? Actually, they are preserving and developing their own culture, because in their educational institute they will impart education according to the culture of their own. So in this way they will be able to preserve and develop the culture of their own. And another thing, another right is this, that the government will grant aid to such educational institute without any discrimination, because there should not be any discrimination by the government in granting aid to such educational institute, and the discrimination cannot be done on the basis that it is under the management of any religious community. Okay, government will grant aid, and this granting of aid cannot be stopped by the government on this ground, that this educational institute is managed by a religious group, because our country is a secular country, and it is expected from the government that it should give equal status to all the religion. So what will happen if the government will grant aid to any educational institute which is managed by a religious community? Then it will go against the concept of secularism. But here the government is giving aid to the educational institute which is managed by not only religious community, but it is minority religious community, and the government is giving it the aid in order to protect the, in order to promote the culture of the minority community. So it can give grant to the religious to the educational institutes which is managed by a minority community. The minority can be religious minority, can be lingual minority. Okay. Now you you must be knowing about madrasas. Madrasa are the educational institutes which are set up by Muslim community. Muslim community is the religious minority community of our country, and they set up their own educational institutions which are known as madrasas. Okay, so this is the our cultural and educational rights. Okay, now we will try to understand the opinion of Sardar Hukum Singh, who was a member of Constituent Assembly, and he shared his view, expressed his view regarding the condition of minorities. So I'm reading this text. A heavy responsibility would be cast on the majority to see that, in fact, the minorities feel secure. The only safety for the minorities lies in a secular state. It pays them to be nationalist. The majority community should not boast of their national outlook. They, should, they should try to place themselves in the position of the minorities and try to appreciate their fears. All demands for safeguards are the product of these fears, and the minority have in their minds as regard their language, their script, and also about the services. So, what Sardar Hukum Singh wants to say that there will be majority and minority always in a society like India, which is a diverse society. And here, what we should understand that the minorities can be safe only in a secular state, because secular state ensure equal treatment to all the people of different religion. No religion will be considered as official religion of the state, and in this way the majority religious group and the minority religious group will be treated in the same manner. And in this regard, what we see that what is the opinion of Sardar Hukum Singh is that the majority community should not boast of their national outlook. It should not be expressed by them as if uh, they are they have the views regarding the nation. They are the protector of the nation. The way it is done in today's time, we can see that some group is such in our society which think that they are the only protector of the national interest of the country. So that should not happen, and they should try to place themselves in the position of the minorities. The majority should think that what will be their state of mind if uh, they were the minorities in the society, and in this way they can think how the atmosphere of fear and insecurity is there in the mind of the minorities, and so there is need of safeguards, and that only we can eradicate the fear and the insecurity that the minorities have in their mind. So in this way we see that the right the one fundamental right, that is right to religious freedom, and the another fundamental right, that is cultural and educational right, both are uh, focusing on the problem of minority, because our country tries to maintain equality among different groups, and there should not be any kind of exploitation by the majority group. So this is adopted by our constitution. Now we are coming to the last right, fundamental right, that is right to constitutional remedies. this is the right which can be said to be the basis of all rights. In we have the constitution has given us the constitution has guaranteed us so many rights. Okay, right to freedom, right to equality, right against exploitation, right to religious freedom, constitutional and educational right. All types of rights are there in the constitution. But what will happen if someone, a person, an institution, a private institution, or a governmental institution deprive us of our right, snatches our right from us, then in that case, what will happen? All the rights will become meaningless. There will be no utility of the rights because the constitution has guaranteed us rights, but there is no provision for that situation. If someone deprive us of our right, then what to do? If that was the situation, then our fundamental right would have become meaningless. But our constitution makers were very much aware of this situation, and so they incorporated this right to constitutional remedy. If anyone, be it a government or a private element, if anyone deprive any person of his right, then in that case, what a person can do? A person can approach a high court or the Supreme Court to get any of the fundamental right restored. Okay, restore for the restoration of the fundamental rights, a person can approach a high court or the Supreme Court. Okay, when there is breach of right or violation of right, and this breach of right or violation of right can be done by government also. And we can go against the government to the Supreme Court or High Court. That is the reason that Dr. Ambedkar considered the right to constitutional remedies as heart and soul of the Constitution, because all the fundamental rights are the basis of the democracy in our country. Democracy cannot be real, cannot be meaningful in the absence of fundamental rights, and all the fundamental rights will become futile, will become meaningless if there is no constitutional remedy. So, in a way, we can say, as Dr. Ambedkar said, that the right to constitutional remedies is heart and soul of the Constitution. Now we will see that the Supreme Court and the High Court has right to issue some orders, and it give directives to the government for the enforcement of rights. If there is violation of rights and a person approach the Supreme Court or the High Court, then in that case the Supreme Court and the High Court has power to issue orders and give direction to the government. And the courts can issue various special orders, which are known as writs. WRITS. These are called writs. And these are special orders of the government, of the courts, which are issued when there is violation of fundamental rights by the government body. Okay, so the first writ is called habeas corpus. Habeas corpus means to have the body. It is a writ, it is an order which is issued by the court, which says that the arrested person, the person who has been arrested, should be presented before it. What happens when that many times uh, police misuses its power, and there may be many influential persons, influential leaders may also be involved in this, And what happens that the police arrest a person, and then that person disappears. There is no um, whereabouts of the person. No one is knowing where that person has gone. In that case, uh, um, any other person who is related to that person can go to the court, and the court will issue habeas corpus to have the body. The court will ask that the arrested person should be presented before it. And when he will be presented before the court, then court has the power. It will see all the matter, and it can decide that the person should be set free, or uh, if the manner or grounds of arrest are not lawful or satisfactory, the court can that can say that the arrested person should be set free because the grounds for which the arrest was done, or the manner in which the arrest was done, was not according to the law. As we have discussed earlier, now there are some rights of the arrested person. So, if the process of arresting is not proper, or the reason of arresting, ground of arresting, basis of arresting is not proper, then in that case the court can set him free also. So, this is the writ, an important writ, which protect the personal liberty of the people. Then there is second writ, that is called Mandamus. It means to give command. This writ is issued when the court finds that a particular office holder is not doing legal duty, and thereby is infringing on the right of an individual. What happens that any uh, office holder, what he is supposed to do, what is his legal duty, he is legally bound to do that duty. Okay, but he is not doing that duty, and in this way the right of an individual is violated. So under this situation, the court can issue a writ which is called mandamus. It gives order to the particular office holder to do the duty, legal duty. Then the third writ is called prohibition. It means to prohibit, to stop something, to stop someone. This writ is issued by a higher court, like High Court or Supreme Court. When a lower court has considered a case going beyond its jurisdiction, whatever was the jurisdiction of lower court, the lower court has not followed its jurisdiction, and it has gone beyond the jurisdiction. Then in that case what happens, the higher court, if the district court has gone beyond its jurisdiction, then the high court of the state can issue this writ of prohibition. If the high court has gone beyond its jurisdiction, then in that case the supreme court can issue this writ. In this way, this writ of prohibition is issued by a higher court to a lower court. Okay, it prohibits the lower court from doing anything which is beyond its jurisdiction. Then there is another writ which is called quo warranto. Quo warranto, it means quo warranto. It means by what warrant? Okay, it requires the person to whom it is directed to show what authority they have for exercising some rights, power, or franchise they claim to hold. Okay, suppose a person is holding office but is not entitled to hold that office. Okay, then in that case what happens that the court issues the writ of quo warranto, and it asks by what warrant, how he can hold, he is holding a post for which he is not entitled, and in this way it stop that person from acting as an office holder. So this is called quo warranto. Then comes certiorari. Certiorari is to certify. Under this writ, what happens? The court orders a lower court or another authority to transfer a matter pending before it to the higher authority or court. These two writs, prohibition and certiorari, is issued by the higher court to a lower court. In this prohibition, the higher court stops the functioning of the lower court. And in this certiorari, what happens? The court order a lower court or another authority to transfer a matter. Okay, transfer it to the higher authority. Whatever matter, any matter may be there, which is pending before the lower court, and the by issuing this writ certiorari, the court, the higher court can ask the lower court to transfer that matter before the higher authority or the court. So, in this way, we can see that these are the various types of writs which can be issued by High Court as well as Supreme Court in order to protect the fundamental rights of the people, in order to in the condition of violation of fundamental rights of the people. And here one more thing you must know, that apart from the judiciary, apart from the Supreme Court and the High Court, there are other organizations also which work for the protection of the rights. These are National Commission on Minorities, National Commission on Women, National Commission on Scheduled Castes, etc. These institutions protect the rights of women. The National Commission on Women, it protects the rights of women. The National Commission on Minorities, it protects the rights of minorities. National Commission on Scheduled Caste, it protects the rights of Dalits or scheduled castes. So these are also working in that direction, and these are extra constitutional development. About these institutions or commissions, there is no description in the constitution. Besides, the National Human Rights Commission has also been established by law to protect the fundamental rights of and other kind of rights. Okay, so in the next class we will we will discuss about this National Human Rights Commission and many more things.